I am delighted to bring to you, as part of the Chartered Institute of Arbitrators Young Members Group Global Steering Committee's regional series, the Spotlight on Australia. Before I introduce the legislative regime in Australia for arbitration, I would like to introduce myself. My name is Erika Williams. I'm an independent arbitrator based in Brisbane, Australia. I established my independent practice almost 4 years ago and primarily sit as arbitrator in commercial, resources and renewables, and construction cases. In relation to the legislative regime for arbitration in Australia, I am pleased to say that Australia is known globally as a pro-arbitration jurisdiction. By way of background, Australia is a federation made up of 6 states and 2 territories. At the federal level, Australia has implemented the International Arbitration Act based on the UNCITRAL Model Law on International Commercial Arbitration. Between 2010 and 2017, the 6 states and 2 territories in Australia implemented what is known as the Uniform Commercial Arbitration Acts, which are also based on the Model Law. This means that at both an international and domestic level, the Australian arbitration legislation is substantively based on the Model Law, providing familiarity and comfort to those involved in Australian-related arbitration. With that very brief background, I would like to provide some case examples of how Australia is a pro-arbitration jurisdiction. The first case example is in relation to the enforcement of arbitration agreements. The other case example is in relation to the enforcement of foreign arbitral awards. The case I would like to provide as a demonstration of how the Australian courts enforce arbitration agreements is a very recent June 2024 decision of SFP Events Pty Ltd and Little Swamp 2 Inc. and Creative Artists Agency LLC. This case involved a North Queensland-based event company, SFP Events, which last year engaged in discussions with John Fogarty, the former lead singer of Creedence Clearwater Revival, to headline the Ditman Bullpit Country Festival to be held in Queensland in March 2024. SFP Events paid a deposit of $700,000 to secure Mr. Fogarty's appearance. However, SFP Events subsequently withdrew the offer and requested the return of the deposit. When Mr. Fogarty's agent did not return the deposit, SFP Events commenced proceedings in the Supreme Court of Queensland seeking its return. Before the court, there was a question as to whether there was a concluded contract between the parties, and therefore whether the arbitration agreement in that contract, which provided for arbitration in California under the JAMS rules, even existed. The question arose in a situation whereby SFP Events paid the deposit in mid-January before Mr. Fogarty was publicly announced as the lead act for the festival and tagged in advertisements for the festival and festival tickets, and before any contract was signed. SFP Events signed the contract it had received from Mr. Fogarty's agent a few days after the public announcement and advertisements. A few weeks later, when SFP Events was chasing a copy of the signed contract from Mr. Fogarty, his team said they had a few questions before they could sign. Less than 4 hours later, SFP Events purported to withdraw its offer. In considering the doctrine of separability, Justice Treston held that the court is not required to decide whether the arbitration agreement exists because the competence principle is wide enough to permit the arbitral tribunal to decide any question of jurisdiction, including whether the arbitration agreement came into existence. Justice Treston made orders staying the proceeding and referring the matter to arbitration in California in accordance with the JAMS rules, as provided for in the arbitration clause. There were a number of other arguments raised in this case, which make for an interesting read for arbitration practitioners, including where, under the civil procedure rules, the court has a discretion to dismiss or stay a proceeding, or set aside service of an originating process that has been served outside the jurisdiction, and the court can do so if the court is an inappropriate forum for the trial of the proceeding. SFP Events argued that the court was not an inappropriate forum and therefore the proceedings should not be stayed. The court held that the proceedings ought to be stayed either because it was an inappropriate forum or in the exercise of the court's inherent jurisdiction. There was also a question as to whether service of the originating process that had occurred outside of Australia without leave should be set aside. The court concluded that service outside the jurisdiction did not require leave as it was permitted under the relevant civil procedure rules. For celebrity watchers, the terms negotiated for Mr. Fogarty's appearance and his rider are also amusing. The recent case of Hankook Carbon Co Limited and Energy World Corporation Limited demonstrates an efficient procedure that the Federal Court of Australia has implemented for the enforcement of foreign arbitral awards in appropriate cases. The applicant, Korean-based Hankook Carbon Co Limited, obtained 2 awards, a Merits Award and a Costs Award, against Energy World Corporation Limited, an Australian company, in relation to the supply and delivery of goods connected with the construction of an LNG storage tank in the Philippines. A dispute arose regarding Energy World's non-payment for completed shipments and non-acceptance of other goods that the parties had contracted for, which remained in storage in a warehouse in Korea. The contract included an arbitration clause providing for all disputes to be finally settled by arbitration. According to the Merits Award, the parties agreed that the 2018 HKIAC-administered arbitration rules would apply and that the seat of the arbitration was Hong Kong. The Merits Award contained orders for Energy World to pay Hankook over $5 million plus warehousing costs, with costs and interest to be determined. The Cost Award contained orders for Energy World to pay Hankook over 2.3 million Hong Kong dollars for costs and expenses of the arbitration, plus interest. Hankook filed an application to enforce the 2 foreign arbitral awards in the Federal Court of Australia. In the Federal Court of Australia, you can apply ex parte for a foreign arbitral award to be enforced when A, the successful party has not been formally notified by the party against whom the award is made that they intend to object to the enforcement of the award and reasons for that objection, and B, the party seeking to enforce the award does not know of any other reasonably arguable basis upon which the unsuccessful party may object to the enforcement of the award. In such a case, all that is required is for the successful party to present the arbitration agreement and the arbitral award, and for the court to be satisfied that the parties to the agreement were also the parties to the awards. They must also provide affidavit evidence of no objection and no reason for objection to the award. In the Hankook case, Justice Stewart found that, as there was no apparent reason why the awards might not be enforced, it was appropriate for the case to follow the ex parte procedure. The court made orders entering judgment, but then stayed that judgment for 28 days in order to provide Energy World an opportunity to apply to set it aside. Hankook was required to provide notice of the orders to Energy World and inform Energy World that unless it opposed or applied to set aside the orders, the stay would expire upon 28 days. Immediately prior to the stay expiring, Hankook provided affidavit evidence that notice of the orders was given to Energy World. As the court had not received any application from Energy World to set aside the orders, the stay expired and the judgment enforcing the arbitral awards came into effect. The entire enforcement process took 2 months, which, in anyone's view, is swift justice. Now that you have heard a little about the legislative regime and pro-arbitration approach of the Australian courts, I encourage you to stay tuned for the next episode in the Spotlight On series.